This courtroom case spirals into one of the most jaw-dropping breakdowns of addiction, second chances, and justice gone full circle. Meet Mr. Sears, a man with 2 felonies, 6 misdemeanors, and a chance at redemption through recovery court. But what happens when someone repeatedly walks away from treatment, commits new felonies while already in jail, and shatters every opportunity given to him? Today, the judge has had enough. You'll witness emotional pleas, harsh truths, and sentencing decisions that stretch all the way to 40 years. Can addiction excuse criminal behavior, or is this just manipulation masked as recovery? Buckle up, this isn't just another sentencing. It's a moral and legal reckoning you won't forget. And by the end, you'll be asking yourself, was this justice or just inevitable?
Sentencing in 3 files, 22-6457, 23-6764, and 23-6765. Counsel, you want to state your appearances, please?
Melissa Goodrich, Boone County Prosecutor.
Jeremiah Buffalo, we're on behalf of Mr. Sayers, who is seated to my right.
Okay, and have you had a chance to review the probation violation report?
Yes, Your Honor, we reviewed it some time ago. The court had been setting these matters out due to Mr. Sayers' other pending matters that are presently here in Sheboygan. We would ask that the court continue to hold that out so we can handle those other matters.
And my only problem with that is now it's alleged that he's committing crimes while he's in our jail, so I'd like to get him out of our jail. So I'm going to proceed with sentencing today.
And there it is, the judge wastes no time. Despite the defense asking for more delays, the court isn't buying it. Why? Because it's now alleged that Mr. Sears committed more crimes while already behind bars. That's not just breaking the rules, that's obliterating them. The moment a defendant commits jailhouse crimes, the court sees it as a red flag for total disregard. The judge is making it clear, leniency has limits, and Mr. Sears may have reached his. The judge is rushing into this, or is he finally drawing the line after too many second chances?
Any additions or corrections to report?
No, Your Honor.
Ms. Goodrich, any additions or corrections to report?
No, Your Honor.
Or anything you want to say on Mr. Sayers' behalf?
Yes, Your Honor. Mr. Sayers is a victim of addiction, Your Honor, and addiction rears its head in many ways, and it has got a hold of Mr. Sayers. Your Honor, I believe that the best possible solution for Mr. Sayers is to be engaged in treatment, and we would ask.
I think so too. And so I sent him to treatment, and he walked off and absconded. So I don't know how to get him to treatment. I agree 100% with you. The problem that we have is that Mr. Sayers doesn't agree with you or me.
In my conversations with Mr. Sayers, Your Honor, he does. He acknowledges that these acts that are alleged are tied to an addiction, and he needs the help. So, Your Honor, we would ask that the court fashion a remedy that allows for rehabilitation as opposed to punishment.
Thank you, Mr. Sayers. It's not required to say anything today, but it is allowed. Is there anything you want to tell me?
I'd just like to say that what he says is 100% accurate. I do struggle with addiction.
That was raw. Mr. Sears opens up about his addiction, his family, and his guilt. And you can hear the desperation in his voice. It's the kind of testimony that could move a courtroom, if only it weren't up against a long record of broken promises. He says he wants help, but the court's heard that before. Remember, this isn't his first relapse. He walked away from treatment, violated probation, and even committed new offenses while awaiting judgment. What do you think? Is this a man seeking redemption, or someone just saying the right words to avoid consequences?
He had made little to no effort during his time in recovery court, actually incurred another case upon release from jail to start recovery court, and now I received a warrant request today for conduct while in jail, waiting the sentence and having the other felony court case pending. So I'd ask the court to follow the recommendations.
The prosecution just dropped the hammer, and it's hard to ignore. Mr. Sears was given recovery court, a program literally built to help people like him turn their lives around. Instead, he used that time to pick up a new case and now faces allegations of jailhouse misconduct.
I definitely need help. I want the help.
Which emphasizes treatment over punishment.
Trying to get there, trying to do it myself.
The prosecution sees only one path forward: prison. And based on what's coming, the judge may agree.
Need me.
Should there be a limit to how many chances someone gets? Or is our system too quick to give up on recovery?
Being on foot from the police during a traffic stop. It's maximum 2 years. 6765, you're on probation for fleeing and eluding third degree, habitual second, 7.5 year maximum. In that case, you fled in a car during a traffic stop, striking a police vehicle. Both high-risk behaviors. In file 6764, you're on probation for delivery of methamphetamine, drug double, maximum 40 years. Possession with intent to deliver methamphetamine, drug double, maximum 40 years. Possession with intent to deliver cocaine, drug double, maximum 40 years. I mean, I've given you so many warnings, and we placed you in the recovery court program despite some of this high-risk behavior. You had multiple violations. We sent you to treatment, and you left treatment and then absconded supervision and had to get arrested. That's not even taking into account that it's alleged that you've committed more than one felony while all that was going on, or while all this case has been going on. Even laying that aside, you've been just out of control, and we have tried to give you every treatment tool in our toolbox.
That's the turning point. The judge has officially exhausted his patience. Every tool for treatment, support, and supervision has been tried. Mr. Sears didn't just relapse, he fled supervision, ignored court orders, and allegedly committed new felonies in the middle of it all. This isn't about failing treatment, it's about abusing the system's trust. And now, the court is done playing counselor, it's reaching for punishment. How do you think judges should balance empathy for addiction with public safety? Is there a middle ground that still protects the community?
You know, what your attorney's saying is a great pitch at the initial sentencing, and I bought it, and I put you in recovery court. And you and I have had several conversations, you and Mr. Fagan, you and Nicole. And I don't know why it just isn't sinking in. And it's not just that you're using drugs. I mean, we've got deliveries, we've got possessions with intent, we've got fleeing from police, we got fleeing from the police in a car, hitting another car. They're high-risk behaviors. It places people in danger. Not just you, it places other people in danger as well. So taking all those things into
The sentences begin. First up, resisting arrest, probation revoked, nearly a year in jail. Next, fleeing and eluding, a 7-year max term. And then comes the heavyweight charges, delivery and possession of meth and cocaine. The judge invokes the drug double statute, enhancing the maximum penalty to 40 years. That's no joke, and while he doesn't double the sentencing guidelines, he hits every top end possible, a clear message that rehabilitation has failed. These are not just numbers, these are years lost. The system gave every option. Now, it's taking back control.
increase the guidelines, but I am going to exercise my discretion to increase the maximum penalty under the statute. So for that case, Mr. Sayers, I'm going to commit you to the Michigan Department of Corrections for not less than 85 months, nor more than 40 years, with credit for 225 days previously served. That's a top end of the guidelines without the drug doubling. I believe that is proportionate, given his absconding supervision and leaving treatment. And again, I'm not exercising my discretion to double those guidelines. I'm leaving them undoubled, but at the top end. I am exercising my discretion to increase the statutory maximum from 20 to 40 years, however. On the count of possession with intent to deliver methamphetamine with the drug double, the advisory guidelines are 72 to 120 months. I would have it within my discretion to double that to 142 to 240. I'm not going to do that. However, because Mr. Sayers walked off of treatment and absconded treatment court supervision while all of this was going on, I'm going to sentence him to the upper end of the undoubled guidelines and commit you to the Michigan Department of Corrections for not less than 10 years or more than 40 years.
This part seals the fate. With multiple counts landing in the 10 to 40-year range, all sentences will run concurrently, meaning at the same time, but even that doesn't soften the blow for Mr. Sears. That still means a potential decade or more behind bars. The judge emphasizes he could have doubled the time, but chose not to. Why? Possibly to reflect proportionality, or maybe one last acknowledgement of Sears' struggles. But make no mistake, this is a harsh sentence, and the judge believes it's completely deserved. Would you have doubled the sentence? Or was this balance between punishment and mercy fair?
Double 40-year maximum, advisory guidelines 10 to 23 months. I'm going to not double the guidelines within my discretion, but sentence you again at the upper end of those guidelines at 23 months to 40 years. Credit for 225 days previously served. Exercising my discretion to increase the statutory maximum, however, not increase the guidelines. And again, top end of the guidelines is certainly proportionate in this case. All right, and Mr. Sayers, you have the right to file, you are able to file an application for leave to appeal if you wish on any of these cases. If you want a lawyer, I give you one, but you have to ask me within 42 days. So we're going to hand you some paperwork explaining that process. One copy is for you to sign. If you want to take an appeal, the other one, we're going to ask you to initial one in all 3 files so that we have a copy of it. And then we'll just have to writ them out or do it by video to deal with the pending cases, but I'll not have you in our jail any longer, sir. Good luck. All those sentences will be concurrent to each other, which I think is required by law on those files, but they're all concurrent to.
And that's it. After years of chaos, addiction, and chances squandered, Mr. Sears has been sentenced not once, but across multiple felony files. Despite emotional pleas, the judge laid down a structured, unforgiving sentence with penalties, reaching up to 40 years. This case highlights a difficult truth. Courts can offer compassion, but only for so long. When treatment is abandoned and justice is repeatedly ignored, even the most patient judges reach their limit. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay sharp, stay informed.